I may mention a matter from the list producer. Leadership supplementary 4 under the readings order. Leadership on the last date, the appellate moved an IA for service of notice through the executing court. Leadership and pursuant to that order, supplementary affidavit was to be filed by the appellate regarding the service of notice. The supplementary affidavit is on record in leadership.
Yes, sir.
We have served it, but the solicitor has denied the acceptance of the notice.
Okay. Anybody has appeared?
No leadership.
Fine.
Item 4 supplementary.
The orders cases are normally taken up at 4 o'clock. You come at 4. Jharkhand.
May I make any question? You have some personal difficulty to appear in the matter in the prefix.
You can see the adjournment. Which item should be adjourned?
25.
What is it for?
It is for order 41B.
Earlier adjourned at your request. File.
Yeah. 25.
There is a matter fixed for hearing at 2:30.
20,000 rupees cost it was adjourned. I am not adjourned.
Pardon?
You can do it as first case. Do it. Open your mouth.
2:30 में fix.
4, 4:30 बजे, 5, 5:30 बजे.
ठीक है. ये पहले हम लोग एडजर्नमेंट लिया हुआ है.
Of course. कॉस्ट लगा के एडजर्नमेंट हुआ. पता होना चाहिए आपको बोलने के पहले.
From the daily list under heading for order 41 rule 11, one item 23 as a first case, second appeal 22 of 2013.
Senior is on legs.
On legs where?
Coming to the court.
Where? In which court he is on legs?
He's outside also.
He is not on legs. कौन सा कोर्ट में चल रहा है मैटर?
Are in the chamber से यहाँ.
ये बोलिए he is in chamber, not on legs.
I apologize also.
ठीक है पास. आने में 5-7 मिनट लगेगा?
Yes, आ गए.
हाँ तो बस ठीक है. जैसे ही आए तो करा लेंगे.
From the supplementary list, item 5, second appeal 310 of 2016.
Pursuant to order dated 17th September, we were directed to file a supplementary on bringing on record the letter sent to the appellant. Appellant has died, Your Lordship. We have filed the supplementary affidavit. The advocate clerk is the deponent of the leadership.
But you have not been able to contact.
Yes, Your Lordship. And in the
When did he
letter,
die?
Lordship, Ladyship, we have no information regarding that. No one has contacted us.
Essay number 310 of 2016. Counsel for the appellant is present. He has submitted that a supplementary affidavit has been filed through the advocate clerk of the counsel on record that the clerk had written a letter to the appellant on 31/7/2005 and then on 3/9/2025. 2025 दोनों 31/7/25 and 3/9/25. But both the letters have returned back with a endorsement that the appellant has died. The return envelope has been placed on record. The learned counsel for the appellant has submitted that he has no instructions in the matter. Accordingly, this appeal is dismissed as abated.
Yes. Much obliged.
Passover case item 23.
there are two judgments your lordship which are under challenge. First is which has been filed title suit number 46/90 corresponding to 195 of 2002, and that has been confirmed your lordship in title appeal number 65 of 2004. Your lordship will please consider the only substantial question of law in the present appeal is whether the Hindu widow is entitled exclusively of the property which is of her late husband, and whether she can, by gift or any other instrument or mode, can give it to another person. This is the only point, your lordship. And this both the learned courts below have committed a serious error. Your lordship may please allow me firstly to point out the issues which were framed and finally concluded. That is at page number 19. Paragraph number 4 at page 19, your lordship.
You just give me the paragraph number of the. You are referring to the trial court judgment or the.
Yes, your lordship. Trial court judgment. Trial court judgment. Internal page 3 of the trial court judgment.
Just a minute. You did not file the trial court judgment along with the memo of appeal. Must have filed it.
It is there, your lordship.
It's not there along with the memo. Yes. Para number?
पैरा नंबर 4 प्रस्तुत वाद में निम्न वाद पदों का गठन किया गया। क्या वाद विचारण योग्य है? क्या वादी को वाद प्रस्तुत करने का कोई वाद कारण है? क्या सुहागी एवं उनके पति ने गंगिया को के प्रभाव में लेकर दान पत्र निष्पादित करा लिया है? क्या वाद संपत्ति पर एकमात्र गंगिया का स्वतंत्र एवं स्वामित्व है? क्या गंगिया द्वारा निष्पादित दान पत्र शून्य है? क्या वादी को वाद संपत्ति से बहिष्कृत कर दिया गया है? वादी और क्या अनुतोष पाने के अधिकारी हैं? पॉइंट नंबर 4 योर लॉर्डशिप ऑफ दिस, क्या वाद संपत्ति पर एकमात्र गंगिया का स्वत्व एवं स्वामित्व है? दिस इज द पॉइंट which needs consideration and which has not been correctly considered by both the courts.
What is the finding of the court?
Finding of the court, your lordship, is at page number 25. गंगिया द्वारा, that is आदेश, गंगिया द्वारा निष्पादित दान पत्र संख्या 3480 दिनांक 5/4/1990 को केवल गंगिया के 1/3 अंश तक के लिए वैध एवं मान्य घोषित किया जाता है। शेष 2/3 अंश के लिए अवैध एवं अमान्य घोषित किया जाता है। 2 daughters are there and the mother who has become a widow. Now the property according to the learned Judge Your Lordship, Upper Nyayadhish Chatur, she is entitled for 1/3 and the two daughters are entitled for 1/3, meaning thereby 2/3 will go to the daughters and 1/3 will go to Gagya. The point for your Lordship's kind consideration is that he is entitled, exclusively entitled for all the property after the death of her husband. This is the only point. That has been decided, Your Lordship. Please just have a look to paragraph 21.
Yes.
In Gogula, Gurumurthy and others versus Gurimeti Ayappa, 1975 Court Supreme Court case 458. This court reiterated the position of a Hindu widow and of greater relevance to us held no one has any vested interest in succession as long as the widow is alive. A Hindu widow is entitled to the full beneficial enjoyment of the state so long as she is not guilty of willful waste. She is answerable to no one. Her estate is not a life estate because in certain circumstances she can give an absolute and complete title, nor is it in any sense an estate held in trust for reversioners. Within the limits imposed upon her, the female holder has the most absolute power of enjoyment and is accountable to no one. She fully represents the state, and so long as she is alive, no one has any vested interest in the succession. It cannot be predicted who would be the nearest reversioner at the time of her death. It is therefore impossible for a reversioner to contend that for any loss which the state might have sustained due to the negligence on the part of the widow, he should be compensated from out of the widow's separate property. He is entitled to get only the property left on the date of the death of the widow. The widow could have, during her lifetime, for necessity, including her maintenance, alienated the whole estate. This is the short gist. And the learned judge had no authority or jurisdiction to say that 1/3 will go to the widow, 2/3 will go to the other two daughters, because the widow is the exclusive holder of the state after the death of her husband. This is the only simple point, Your Lordship, which there is another judgment.
This is all prior to Hindu Succession Act.
Prior to Hindu Succession Act, Your Lordship, and this was.
The entire case is prior to Hindu Succession Act.
Besides that, Your Lordship will proceed. All these things have not been taken into consideration by the learned.
No, but you see, this is guided by Hindu Succession Act.
Yes,
This
Your
present
Lordship.
case,
Yes.
you place from the Hindu Succession Act. You place how the property will devolve upon the legal heirs upon death of the. Does it devolve upon the sons or it does not devolve upon the sons?
If the Hindu widow is alive, Your Lordship, she will be the only exclusive.
Only successor.
Yes.
Show me from the Hindu Succession Act.
Please just have a look to section 14, Hindu Succession Act.
Property of a female. It is not a property of female, it is a property of male.
No.
Property
After
of
the
a
death-
female Hindu to be her absolute property.
After the death of her husband, the property becomes the property of...
No, this will not govern. This will not govern. This will be governed by death of male here.
The
Class 1 here will take simultaneously as per section 9. All of them they fall under class 1 here.
wife...
Wife
or
and
your
children, they
children,
all fall under class 1 here, or
Class one.
children would come class 2 here.
Class 1 year.
Class 1 here. So as per section 9, those in class 1 shall take simultaneously and to the exclusion of all other years. Therefore, it will devolve simultaneously to all the class 1 years.
The married daughter thereafter,
It makes no difference after Hindu Succession Act.
56.
Yes, it makes no difference.
But all those things have...
Married, unmarried, it makes no difference.
Thereafter, your lordship, the gift deed,
Which is son, daughter, widow, all fall under class 1 as per the classification.
but section 14, your lordship, we rely upon section 14.
You read section 14.
That once your
You
lordship...
please read section 14.
Property of a female Hindu to be her absolute property. Any property possessed by a female Hindu, whether acquired before or after the commencement of this act, shall be held by her as full owner thereof and not as a limited owner. In this subsection, property includes both movable and immovable property acquired by a female Hindu by inheritance or device or at a partition or in lieu of maintenance or arrears of maintenance or by gift from any person, whether a relative or not, before, at or after her marriage, or by her own skill or exertion, or by purchase or by prescription, or in any other manner whatsoever, and also any such property held by her as freedom immediately before the commencement of the act. Nothing contained in subsection 1 shall apply to any property acquired by way of gift or under a will or any other instrument or under a decree or order of a civil court or under an award where the terms of the gift, will or other instrument or the decree, order or award prescribe a restricted estate in such property. So, our humble submission before your lordship is that after the death of her husband, this property devolved into the possession of the present appellant, Gangya Devi, and by a deed of gift, she gave it to Mahesh Prasad Sahu, one of her grandsons.
Okay. Second appeal number 223 of 2013. Heard the learned counsel for the appellant. This appeal has been filed against the judgment dated 27th of June 2013, passed in title appeal number 65 of 2004. Thereby the learned first appellate court has dismissed the appeal. The trial court judgment was passed in title suit number 46 of 1990 by learned subordinate Judge Romanpur Dhanbad on 22nd of March 2004. entitled suit number 46 of 1990. The sole defendant is the appellant before this court. The suit was filed seeking a declaration that the gift deed number 3480 dated 5/4/1990 is void with respect to the Schedule B property. The learned counsel for the appellant has submitted that the gift deed has been held valid by the learned trial court only to the extent of 1/3 share of the which was attributable to widow and 2/3 share was directed to be of that of her two daughters. He has further submitted that the parties are governed by Mitakshara School of Hindu law and Mitakshara hai na sab?
जी
Mitakshara School of Hindu law and has referred to section 14 of the Hindu Succession Act 1956 to submit that the entire property of her late husband would have devolved exclusively to the widow. And therefore, the registered deed of gift executed by the widow with respect to the entire property was valid in the eyes of her. The learned courts have erred in holding that it was valid only to the extent of 1/3, and therefore a substantial question of law be framed of this court. He has referred to the judgment passed by Honorable Supreme Court, passed in Civil Appeal number 1332 of 2008, within bracket Gopal Krishna versus Narayan Govda. To submit that the property would devolve. The widow has had absolute power with respect to the suit property. It is referred to paragraph 21 of the same judgment, which in turn referred to an earlier judgment reported in bracket 1975 bracket close 4 SCC 458. After hearing the learned counsel for the appellant, this court finds that as per the case of the plaintiff, the land in Schedule B belonged to and was in possession of Rupan Mehta, the father of the plaintiff, who died leaving behind his wife, Gangiya Mehta, and two daughters, namely Sogani Mehtain and Dumri Mehtain, the plaintiff. It was a specific case of the plaintiff that all the three were the class 1 legal heirs under Section 8 of the Hindu Succession Act, and they all inherited jointly the property left by Rupal Mehta and were in joint enjoyment of the property, and none had a distinct share in any distinct plot of the land. It was also the case that Sughani Mehtain, one daughter, was residing in the house of Gangia Mehtain as her husband was working in Dhanbad. It was further case that due to close contact of Sohagi Mehtain with her mother, she got much influenced and command over Ganga Mehtain, and taking advantage of this, Sohagi Mehtain and her husband instigated Ganga Mehtain to execute a registered deed of gift in respect of the suit land. And ultimately, Gangia Mehtain executed the registered deed of gift in respect of the entire land, claiming herself that Rupal Mehta had died, leaving behind Gangia Mehtain as the only legal heir and successor, and executed the registered deed of gift bearing number 3480 dated 5/1990, which was alleged to be void ab initio. The defendants contested the suit. However, it was admitted that Rupal Mehta was in exclusive possession of the suit land, who died leaving behind Gangia Mehtain and his two daughters, Swahagi Mehtain and Purni Mehtain, the plaintiff. But the joint possession of the property was denied. It was asserted that the defendant number 1 was in exclusive possession of the same since 1972, and the plaintiff had no concern with the suit property. A plea of adverse possession was also raised by defendant number 1 with respect to the remaining share and becoming absolute owner of the property, ousting the other co-owners. It was contended that the defendant number 1 had voluntarily and with a free will executed the registered deed of gift in favor of defendant number 2 out of love and affection. However, it was admitted that defendant number 1 was having 1/3 share to the said land under the gift deed. The learned trial court framed the following issues for consideration. The learned trial court ultimately held that the suit property, that the gift deed was valid only to the extent of 1/3 share of Gangia Mehtain and was declared to be void with respect to 2/3 share, which were that of the two daughters. The learned first appellate court also considered the case. And frame the and observed that and gave concurrent findings and dismissed the appeal. The learned first appellate court has considered that, has held that it is well settled principle of law that possession of one co-sharer is joint possession, is presumptively possession of all the co-sharers. It was an admitted fact that the suit property belonged to Rupal Mehto, who had no male issue, and it was not in dispute that Rupal Mehto died leaving behind his widow Ganga Mehta and two daughters, Sohagi Mehto and Pinky Mehto. The learned court came to a conclusion that there was no perversity in the finding recorded by the learned High Court that after death of Rupal Mehto, his two daughters have equal shares with Ganga Mehta in the state house, and she had right and title over the property in question only to the extent of 1/3. The learned counsel for the appellant, by assailing the judgments, has referred to section 14 of the Hindu Succession Act to submit that the widow had the exclusive right over the property during her lifetime after the death of her husband, and no right was acquired by his two daughters. On the face of section 14 of Hindu Succession Act, it is relatable to property of a female Hindu, which, as per this provision, is her exclusive property, even if she acquires the same through inheritance. The same provision does not apply to the facts of the case. Rather, as per section 8 of the Hindu Succession Act, the property of a male dying intestate shall devolve according to the provision of the chapter, firstly upon the heirs being the relatives specified in class 1, and as per section 9, amongst the heirs specified in the schedule, those in class 1 shall take simultaneously to the exclusion of other heirs. Class 1 heirs include sons, daughters, and widow also. On the plain reading of Hindu Succession Act, section 8 and 9, there can be no doubt that the property devolved equally amongst all the three, widow and two daughters. The provision of section 8 of the Hindu Succession Act was also relied upon by the court. Accordingly, this court is of the considered view that both the learned courts have Accordingly, this court is of the considered view that no substantial question of law is involved in this case. It is accordingly dismissed.
Item 24, second appeal 373 of 2018.
Serious strategy emotion is not in Ranchi.
There was adjournment on the
Before
urgency.
the coordinated units of the
Sorry? How much cost will it be? Just
any date will be fixed for Ranchi.
Today is the date.
Traveling your worship.
no problem. You are not given any advance notice for circulation or adjournment. I will not adjourn it without cost.
What should be fixed for tomorrow your worship?
Tomorrow also you have to pay cost. For tomorrow also you will have to pay cost. We have given you the liberty to call our courtmaster anytime, message our courtmaster anytime. They receive your messages anytime, but you don't avail it. I have read this brief. I will not adjourn it like that. Either you argue or I will adjourn.
Tomorrow your worship.
No.
Tomorrow is the
No, you
first
are.
day, worship.
No. Nothing. I will adjourn it for tomorrow, subject to cost. देखिए essay number 378 of 2018, the learned counsel for the appellant seeks adjournment. No advance notice seeking. Adjournment has been circulated. Earlier, the case was adjourned on 2 occasions upon payment of cost, that is on 7/2/23 and 16/7/24. When do you want? In order to give one more chance by way of last indulgence, the matter is adjourned and is directed to be posted on September 25th September, subject to payment of cost of ₹5,000. वही Advocate Association. The receipt regarding payment of cost should be filed before the registry by tomorrow, failing which the case will stand dismissed without further reference to the bench. इस order को जल्दी से sign
Can I
करके आप
request,
लोग-
your worship, can I request a short pass on one case, your worship?
No, I have already
I just
passed
seek
order. Please.
instruction, your worship.
What is
No,
this?
I see,
No,
no.
tell call them. Next.
Item 25, second appeal 375 of 2018.
Yes, appellant.
Ask for a few questions to lies on this.
This case was passed over. Yes. What time? Any time is right time. Right time is now. Tell me.
Yes, mistakenly took the brief also. This is the first time we are
Just
appearing
taking the brief also with you.
mistakenly. Actually, we have filed the Vakalatnama in May or
We don't
already.
bother about
Didn't-
We don't bother about it. If there he comes.
Additional, first of all, accept my apologies, please. I gave a wrong answer at that time. I got introduced in this case after that order was passed. I should have
taken
seen
care.
that. I should have seen
You see,
that.
we
order.
take your words
Yes,
for
I'm very, very.
these
impressed.
orders are all uploaded orders.
Yes.
So you cannot say ignorance. You cannot plead
I'm
ignorance. Right? So anyways, you are
May. Leadership, we are the unsuccessful defendants in first appeal. And there is an IA to be pressed. You filed an IA number 2766 for amendment in the memo of additional substantial question of law has been proposed.
You just
I'm just pointing out.
done, because at this stage, notice has not been issued, you can argue whatever you want.
And one thing I would like to propose, taking instructions, the judiciary may consider sending this matter for mediation also. It's a family dispute, right?
I don't know. Who has instructed you? Who has instructed you? Tell me the name of the appellant. I'll record it. Then I will simply send it to mediation and you have whatever you have to do in the mediation. Notices will be sent from there only.
Because we tried this in one case and we kind of succeeded, therefore I thought.
Who has instructed you? Tell me the name of the person.
May I just confirm this? The dispute is between the so-called settlee of my.
It is not a
Father.
family dispute.
No, that's what I'm saying. The dispute is between a so-called settlee of my father.
It does not appear that it can be settled through mediation. Two distinct persons are claiming title over the property. Very unlikely. You will not send it to mediation like that. You just argue your case.
Yes. Because why I said this was because this one person, there is only one person who has contested. Others in the family, there is something. Therefore,
No, it doesn't make any difference. One person from the family can contest
yes,
the title.
legally yes.
Yes, you argue your case.
The original suit was filed for title, declaration of title. It was founded on Sada Hukumnama, and the court has believed the Hukumnama which was placed by that party, and your ladyship knows that in case of a Sada Hukumnama which is alleged to have been executed prior to vesting, title can be derived only if a return has been filed. A peculiar feature of this case is that both courts, they disbelieve the returns filed by both parties. In that case, the plaintiff suit will fail. That's not the contentions which I have advanced in my supplementary affidavit which I have filed.
What is your first substantial question of law?
So that first substantial question of law is the judgment in suit is against a dead man.
Is that correct? Is this fact correct? When did he die? What is the date of death? You must have taken this point up before the appellate court also.
They are slightly disobedient.
You were the appellant?
I was the first appellant.
Whose responsibility is to make the substitution? You have made the dead person as a party in the proceedings. You were the defendant.
I was the defendant. In addition, may I come to the additional question of law which I have proposed?
No, but
First-
if it
first,
is a nullity matter ends, we'll hear nothing. Nothing is to be heard.
I'm not able to.
So you just, if you are not able to say, it's very unfortunate. Yeah, that is your first substantial question of law framed.
Because when it came to me, I did my exercise and found out the other couple of substantial questions.
Need not. If it is a nullity matter ends, we'll not hear anything, we'll simply set it aside. Permit you to substitute. What was the name of this person who has died? Ramakrishna Lal.
Alias Motila.
No, he was substituted. He was substituted. You see the degree. His wife was substituted and then deleted by the order dated 22/5/18.
But the suit was filed itself against him.
We do not know.
The substantial question of law suggests that when the suit was filed, he was dead.
That is a suggestion. From where do I get? You must have at least taken this point before the first appellate court that it is against a dead person. Where is that? And if he was dead, where is the question of substitution? He was substituted.
If he has died during the pendency, then substitution of course.
Yes. Where is the question of substitution? Did you assail that order of substitution at any stage?
His alias name is Kishore Lal Gupta.
His name is Ramakrishna Lal Gupta, alias Motilal Gupta. There is no third alias name. As per your memo.
Yes.
Okay. Essay number 378 of 2018. The learned counsel for the appellant is present. The first substantial question of law, as has been proposed in a memo of appeal, is whether title suit number 16 of 1993 filed before the learned trial court against dead person, namely Ramakrishna Lal Gupta alias Motilal Gupta, as defendant number 3, and the entire proceeding and judgment passed by the learned trial court against a dead person is a nullity. However, during the course of hearing, the learned counsel for the appellant is totally unable to give the date of death of Ramakrishna Lal Gupta. It further appears from the decree passed by the learned first appellate court that his wife was substituted. His wife Bimla Devi was substituted and her name was also deleted by the order dated 22/5/2018. The counsel for the appellant appears to be totally unprepared with the case. Post this second week January में कर दीजिए, आराम से तैयार होकर बहस करिए. सेकेंड वीक जनवरी के मंडे को कर लीजिए.
Item 26, second appeal 397 of 2018.
Yes, Your Lordship, this brief was held by Mr. Prashant Raju, Your Lordship. Now he cannot appear in private matters. So
Sorry?
Your Lordship, this brief was held by Mr. Prashant Raju. Now he cannot appear in private matters.
Right? He has been appearing.
No, Your Lordship, on Friday, Your Lordship, the notification has come regarding his additional solicitor. He has been appointed additional solicitor.
He can't even take up private
No, Your Lordship.
civil matters.
No, Your Lordship. So, Your Lordship, we need to engage a senior in this matter. Praying for 2 weeks' time.
There are other advocates on record.
Your Lordship, although we need to engage a senior, Your Lordship, in this matter. Therefore, I am praying for 2 weeks' time, Your Lordship, in this matter.
SC number 397 of 2018. MS, sorry,
Shiva.
Shivani Jalukka.
Yes.
Advocate submits that the case was to be argued by Mr. Prashant Pallab, who is also the advocate on record. However, on account of subsequent development, he is unable to appear in this case. She submits that a senior counsel has to be engaged and seeks adjournment. आप लोग एडवांस नोटिस क्यों नहीं देते? उसके लिए भी वो सीनियर हो गए हैं. So, why are you so crippled?
Your Lordship,
Are you not comfortable with the technology? Do you have any problem in giving messages to the court master?
No, Your Lordship.
Then,
Your Lordship, I apologize for this.
the case was adjourned on previous occasion by imposing cost. It is unfortunate that the counsel for the appellant has not given any advance notice seeking adjournment. However, in order to give one more chance by way of last emergence, choose your date. When do you want? Choose your date.
Your Lordship, after Diwali
You-
vacations.
Which Diwali? 27, 28? Give the date.
Yes.
You prayed for 2 weeks time, no? When is 2 weeks expiring? Post on 14th October.
Item 27, second appeal 422 of 2018.
Lord, it is the plaintiff's second appeal. The suit was declared, appeal has been passed. Lord, it was declaration, my Lord, for title with respect to, my Lord, 57 and half decimal, my Lord, of plot number, my Lord, 381 under khata number 21. '56 and half. This was the, my Lord, the suit property. My Lord, the total area, my Lord, including of khata number 21 of several plots, Your Lordship, it was 8 acres, my Lord. It was recorded in the name of, my Lord, 2 brothers. My Lord. One brother, Your Lordship, sold the half of the property to one, my Lord, Bhagwat Prasad Singh. And my Lord, he scooted several centimeters.
One of the brothers sold it.
One of the brothers, Ramdev.
There were 2 brothers.
There were 2 brothers, my Lord.
Katyani Rayed was
Khatyani
Halkhori Gwala.
was Halkhori Gwala
and
and Gandori.
Gondari Gwala.
So Gandori Gwala's son Ramdev Mahato, she scooted selling, my Lord, in favor of Bhagwat Prasad Singh for 4 acres. And my Lord, plots numbers were also mentioned, but there was no boundary attachment. So, his share he sold.
His share he sold.
His share he sold.
Ramdev Mehta, son of Gondari Mehta.
Son of Gandhari. Who was son of Chaman, who was the recorded tenant. Then Malad, the Ramdev Mahato, when he sold to Malad Bhagwat Prasad Singh, then Malad, he scooted several cedits. And Malad, he almost sold his property. That is the finding Malad, of the
But he acquired only 4 acres
Yes.
out of 8.
Out of
And 4 acres was only sold.
4
Sale
acres.
dated 4259.
There were several plots under Khata number 21.
Yes.
But Malad, the learned trial court has I will show that those charts, Malad, on the basis of charts, Malad, the learned trial court has Malad hold that nothing remained as such. Malad, this plot in question was basically with the Malad, the plaintiff's ancestors itself. And Malad, the area which was sold, thereafter Malad, there was no occasion for his son to sell the land in the year 87 to the defendant.
No, I'm not able to get it. You see,
Malad,
there are 8 acres of land involved.
Yes.
With respect to plot number 381.
No, entire Khata number 2.
No, your plea is only in connection with plot number 381.
Yes, but
Your suit is only in connection with plot number 381.
381, your worship,
Yes.
we are only concerned with 56 and half. With the Malad, the area is, total area is 57 decimals.
Plot number 381 has 57 decimal.
Yes, Malad, it
But
appears.
Khata number 21 has 57.
Khata number 21 has 8 acres.
8 acres.
That was recorded in the name of
Plot number 381 has how many decimals?
It is 57. 381.
381 has how many decimal of land?
57.
57. That is 56 and a half.
We are claiming.
Okay. You are claiming 56 and a half.
What is my pleading, your worship, is that this particular piece of land, Malad, over which we are claiming title, it always remained with us, and it is the finding of the Malad, the trial court also. Trial court, Malad, after taking into consideration entire cell deeds, entire area, etc., Malad, has come to a finding that that plot was with us. That finding has been reversed. That is one of the points. Second aspect, in the year 1987, son of Bhagwat Singh, his name is Randhir Singh, he has disputed Malad, the sale deed for this portion of land, Malad, in the favor of defendant. Then when he started Malad, interfering with our possession, etc., and when we had asked for a demarcation of 380 and 381 Malad, plot number, then Malad, the cause of action Malad, accrued to us, and we instituted this. Malad, may kindly see the finding of the Malad learned trial.
Has there been any partition?
They say
What is the finding?
no partition document has
They have not been able to prove partition.
No.
If they have not been able to prove partition, then you go for partition.
No. So far as the partition, your lordship, is concerned, the pleading is that as per the oral partition, 4 acres was already sold.
This is the pleading of the plaintiff or
The
it is
plaintiff, this is the
plaintiff.
plaintiff's pleading. What is the pleading of his defendant, your lordship? He is claiming this land. Defendants, Malad, the purchaser of the defendant is claiming this land. That the Randhir Singh, Malad, got this land in the settlement. From his father.
plaintiff. You are the plaintiff.
I am the plaintiff.
What is your case?
My case, your
You tell
lordship.
us how you have to prove your case. how you have
My
to
case, your lordship, is that Malad, that the defendant, Malad, number 1, who has purchased the land from Randhir Singh, he has no title, as because the Randhir Singh himself has no title, Malad, to dispute a certificate with respect to this piece of land.
Randhir Singh is son of Bhagwat Singh.
Bhagwat.
When Bhagwat Singh had title, why Randhir Singh would not have title?
And because he has already sold it. For 4 acres he could have sold. He have sold my lord 3.99 on our audit
To whom?
to several purchasers, including me also.
Okay. And thereafter, above 4 decimal was sold by his son.
He is saying that this much of land he got in the settlement from his father, but he has not produced any partition document or any settlement document that I have got this land from his father. This is also the finding of the trial.
He claims it, he does not claim it by inheritance.
No, he is saying that his father, in partition among the other members, he gave it to him. But the question is,
See,
if the
if the property is belonging to father, when did he die?
that date of
He is
death
not
of-
claiming any inheritance.
No, he is saying as such his pleading is that this piece of land along with other lands also was given to him from by his father. This is what is the net pleading. But the question is, when the father himself sold the property, where is the question of giving these all things to him? Apart from that,
You are saying that father himself sold the property, and then you say that the property of father was sold by him. What is the correct picture? You see, there is Ramdev Mehto.
Right. Ramdev Mahato sold to Bhagwat Singh.
Mehto, deed number 5273, right?
Yes.
Sold to Bhagwat.
For
Bhagwat sold to whom?
Bhagwat Singh.
Who? He sold to whom?
Ramdev Mahato sold to Bhagwat Prasad Singh.
And then?
Then the Bhagwat Prasad Singh, he disputed sale deed.
Which sale deed?
Yes,
Sale deed number?
I'm coming to that. Exhibit 1, Your Lordship, is the, may kindly see trial court judgment, page 45. Certified copy of sale deed 3579, 12/7/1974 by Bhagwat Prasad Singh in favor of Natho Dusad and Sakal Dusad for 1.47 acres, 9 plots of khata number 21. Then, my lord, exhibit 1A, certified copy of sale deed number so and so in favor of Ramdev Mahato in favor of. This is what I was saying. Exhibit 1 by A is the 4 acres of land of his share. He has sold it to Bhagwat Prasad Singh. Then, my lord, the Bhagwat Prasad Singh, my lord, further sold 1.46 in favor of Natho Dusad and Sakal Dusad.
He sold 3.99 and a half acres out of 4 acres.
Yes, that's what is the finding. That's what is the finding.
Okay, and this was as per the plaintiff's case also.
This is my case.
This is your case, right? Then Meghan Mehto, his son,
Then a trial court has concluded, Your Lordship, that the property, so far as the 380 plot number 381 is concerned, it remained with the Meghan Mahato, Meghan Gop itself, and so far as the property is concerned, the share was 4 acre share was already sold. That what is the finding? May kindly see. May kindly see, my lord, page
the
55.
land was mutated in his name.
Land was mutated in the name of the the defendant number 1 pursuant to purchase, my lord. Pursuant to
No, the
purchase.
land was mutated in the name of his son also, Meghan Gop.
No, Meghan Gop is my ancestor. We are claiming through Meghan Gop. It is my Khatiyani land. So far as the 4 acres of land is out of 8 is still with us. It is still with us.
So, by which sale deed his son has sold?
Yes, 1987.
Where is the description of that sale?
Yes. It is exhibit 1 by C. May kindly see page 45 of the trial court. Certified copy of SEBI 4368 of dated 19/10/97 by Randir Singh in favor of Suryadev Yadav. Total area 89, out of which 57 in plot number 281. 381. That's
What is the finding of the trial court?
Yes. Before my lord, placing the finding, I would like to show page 55. You must have kindly see page 55. My lord, the learned trial court, my lord, made a threadbare analysis of all the my lord, the cell leads and etc. And my lord, then my lord, it recorded a finding that is on page 56. My lord, second paragraph I would like to read. First, second, third paragraph. It is well settled law that a partition may be inferred from the cumulative circumstances and acts of the parties. In the present case in hand, though the said deed of Harvard authority
Where are you reading? I am not able to get it. Page number?
56.
56.
Running
Which paragraph?
नीचे से दूसरा
It is well settled.
It is well. Partition may be informed from the cumulative circumstances and the acts of the parties. In the present case in hand, though the said deed of Bhagwat Prasad Singh does not make clear as to which plots were purchased by him in khata number 21, but the exclusion of 3 said deeds by him in the year 1974 itself with a specific area of each plot makes it evidently clear as to which plots were actually purchased by Bhagwat Prasad Singh and which were in the possession of Ramdev Yadav, son of Gandori Gwan. The table shows that the land of plot number 381 remained with the Megan Mahto, who is the father of plaintiff number 1 and grandfather of the plaintiff number 2 and 3. The table makes it clear that total area of 381 was not sold to the Bhagwat Prasad Singh. Hence, here the plaintiff are claiming 56 and half decimals of plot number 381, giving half decimals. The above table makes one more thing clear that the total area of 175 of 28 is 8 decimals in the Khadian, whereas in that plot the area through 2 centimeters come to Natho Disad is 4.5, so the total area is 9 decimals. The slight difference in area may be due to the difference in the map and actual measurement for the other regions. What I would like to go by the area in the Khadian, by presumption of correctness is attached to section 84 of Chota Nagpur Tenancy Act, whereas the sale deeds are document between the 2 private persons, even if it is registered. Therefore, presuming that the entry in Khadian is true, this at least shows that total area of Khadian sold by Bhagwat Prasad Singh comes to 3.98 and half actually, and not 3.99 and half as claimed by the plaintiffs. Further, table shows that the total remaining area to Megan Group is 4.01 half acre, that is 1.5 acre more than his share. Since whole case of the plaintiff is based on calculation as per the 3 deeds in view of the above discussion, plaintiffs are able to prove they are entitled to 55.5 decimals of land at plot number 381 in Khata 21 and should not 56.5 of Schedule B as paid. It is well settled that the principle of law that no one can transfer a better title than himself. In the present case, it is admitted.
Do you have any grievance with this finding?
Madam?
Do you have any grievance with this
No.
finding?
In present case, it is admitted that the defendant number 2 has got title through the father, Bhagwat Prasad Singh, as stated above. On the date of the execution of sale deed by defendant number 2 in favor of defendant number 1 or after 1974, Bhagwat Singh had no title on the suit land, at least on 55.5 decimal land as discussed and found earlier. So, any transaction if made by the defendant number 2 in regard to suit land is void ab initio to that extent. The purchaser defendant number 1 has not acquired any title so far as the 55.5 decimals of land plot number 381 is concerned. And so his legal heir, the substituted defendant. Therefore, it is here the defendant number 2 had no title to issue exhibit 1 by C did sell deed number such and such with respect to area 55.5 decimals out of 57 and the schedule B to the 1, therefore is legal, null and void to the extent thus non-binding to make. This finding, Your Lordship, has been reversed by the learned appellate. My lord, may kindly see learned appellate court.
Para 10 is the only point of determination,
Yes.
whatever,
I'm
whether it
coming.
suffers from any
That is para 10.
factor, yes. And
Only
there is
point
the
of determination which has been found, my lord, that whether the judgment and decree of the trial court suffers from any legal factual defects and legal interference. No specific. Then, my lord, the finding also, my lord, para 11, the case of the my lord, plaintiff has been discussed. Plaintiff, defendant has also been discussed. And thereafter, my lord, only one of the witness, that is PW1, he has discussed. And straightway has come to the finding that therefore I find that the respondent plaintiffs have failed to prove his title and position. That is at page 20, returning page 23, page 17. May I permitted to read? These cases they have discussed that regarding the exhibits, etc. But contents he has not been able to properly construed as followed the construed by the learned trial.
which paragraph are you reading?
It is page 33, para 14.
The discussion starts from para number.
The 11 is discussions.
Yes, it starts and every document has been discussed.
Only few documents
No, not
that
few
have been
documents.
discussed. That has been discussed, but the contents etc. which was clearly and meticulously
No,
examined by
contents
the
has
trial.
been examined. You can't say, you read para number
Yes.
13, you read para 13.
Yes, I find from the
No, para
judgment
13.
para 11 I am reading. Finding portion.
No, you see, let us see the case of the defendant, you are against that only, para 13.
Para 13. Defendants have denied possession of plaintiff's over Schedule B land. Surajdev Yadav, father of the substituted defendant number 1, has purchased the khata number 21, plot number 381, area of 0.057 Chakla by virtue of registered sale deed, and grandfather substituted defendant Latu had purchased land 21 of 380 area 0.9 by registered sale deed from Megan. Both the plots of khata 21 have amalgamated together. Thereon the Kita proposed house and Pakka well and housing colony has been erected. He has denied the genealogical table of Schedule A. He has further submitted that Harkori Mato and two sons, Gadari and Meghan. He was saying that the Harkori had two sons, but the trial court has rightly disbelieved it, and it is also from apparent from the Yan also and the Sediments. Harkori Mato had two sons, Gadori and Meghan Mato. Ramdev Mato sold 4 acres of land of village Chakla, Paragna, Janta by registered sale deed 4259 dated 5/12/1973 in favor of Bhagat Prasad Singh, and he came in possession over the purchased land in his lifetime, made settlement to all his sons by the oral amicable partition. This document has not been brought on record.
Oral amicable
Double
partition का क्या
कोई
document?
मतलब ही नहीं,
नहीं, ऐसा तो नहीं है कि oral partition नहीं हो सकता.
कोई गवाही तो लाएंगे.
गवाही लेके आएंगे.
गवाही लेके
लेकिन
आएंगे.
ऐसा नहीं है कि oral partition नहीं हो सकता.
नहीं, ओरल पार्टीशन हो सकता है, लेकिन सवाल है कि लैंड भी तो बचना चाहिए. जो जब रजिस्टर्ड सेल डीड के अगेंस्ट में इनका ओरल पार्टीशन का क्लेम कैसे बिलीव किया जाएगा? अगर कोई रजिस्टर्ड सेल डीड नहीं होता, अगर 4
What is the date of oral partition?
ये भी नहीं लिखे, वेट प्लीडिंग है. सिर्फ लेफ्ट हैंड लिख रहे हैं, The khata number 21 of plot number 57 acres and others had been allotted to share of Ranveer Singh. ये कह रहे हैं कि हमको allot हुआ. He came in peaceful possession over his allotted share and sold the same through the sale deed in 1987, and plaintiff has purchased an area of 1.05 acres out of 4 acres from his Bhagwat Singh. It is very much clear that Exhibit 1 by A certified copy of sale deed dated 5/12. Here, this sale deed has been executed by Ramdev Mahto in favor of Bhagwat Singh in respect of the land of the village Chakla, land of khata number 21, total 23. Lot number 23, 8 acres, out of which 4 acres of the same was sold in the favor of Bhagwat Singh. खुद भी कह रहे हैं कि ये sold कर दिया. Exhibit 1 is the certified copy of the sale deed. This sale deed has been executed by Bhagwat Singh in favor of Natho Prasad and Sakal Prasad of khata number 21 of different lots area 1.47. Exhibit 1 by B certified copy of the sale deed bearing 3580 dated 12/7/74 in favor of Natho Prasad, land of khata number 21 village Chakla, Magna Danta of different plots, total area 1.46 acres. Exhibit 1 by D is the certified copy of the sale deed. This deed has been executed by Bhagwat Singh in favor of Nanak Mahto, village Chakla, Paragna Danta district. These are all my cases which they are admitting. Land of khata number 21 and land of khata number 72, 1.15 acres. Total area of khata 72, plot 362, area 33, plot number 358, area 0.12 acres, total area 45. Since this land lot is not in dispute, only dispute
The
is
suit was
regarding.
held to be barred by section 34 also.
It cannot be. How it can? The trial court has rightly concluded it cannot.
What is the finding of the learned trial court on section 34?
Lordship, may kindly see para 35.
Yes. Read it please, finding.
Yes.
Hence in the present case, here in the
Hence,
present
the
case.
present court has discussed the provision. Thereafter, in the present case, plaintiff had brought this case for declaration of title and for exemption. I am of view that the plaintiff is covered in this section. Further, plaintiff have apprehension that the defendants are in possession of some portion of land semi-adjacent to 380, which is admittedly in possession of defendant number 1. And the demarcation could not be done as per the case of the plaintiff in the pleading, and the demarcation of the suit may be one of the prayer. However, this may be considered in the other reliefs.
No clear finding.
It can be
Finding is-
considered करके लिखा है, लेकिन बाद में order.
However, this may be considered in other
Other
relief. So there is no clear finding. on
Clear
this.
finding नहीं है, लेकिन लिखा है.
तो कहाँ पे है अदर रिलीफ में कहाँ
कौन
को
पता?
कहाँ डिस्कशन है सेक्शन
तो लिखा है जो इसमें 38 में लिखा जाएगा. Whether plaintiffs are entitled for the reliefs as sought for or any other reliefs. Plaintiffs have proved their title on 55.5 decimals land of Procedural B property. Formally, during evidence, it comes out that the original defendant number 1 was in possession. It came out that the parties tried to demarcate for number 380 and but failed. Plaintiff have not asked for delivery of possession in clear terms, but have paid a foreign court fee. In the facts and circumstances of the present case and the finding given on the main issue, it is necessary to give effect to the decision. Therefore, keeping in view of the convenience of parties, it is necessary to direct the substituted defendants in place of defendant but to cooperate with plaintiff in demarcating the suit land. And as per this decision, for peaceful enjoyment of the respective lands by both the parties, and further defendants are directed not to interfere in the possession of the remaining 55.5 decimals of land for which the plaintiff have title, remaining in possession of such and such, which is adjacent to plot. Title इनका होल्ड किया. हमारा और भी अदर रिलीफ्स भी था, इस सब चीज़ को विचार करके ऑर्डर किया। इस पॉइंट पर के इसमें इनका जजमेंट ठीक है। अपीलेट कोर्ट तो ऐसे ही कर दिया, इनका प्रॉपर इसमें इस पॉइंट पे डिस्कशन भी नहीं।
क्या सब्सटेंशियल क्वेश्चन ऑफ लॉ?
एक तो बी है, whether the learned appellate being final court of law and fact failed in its duty examining the two parts of exhibit 1 or 8, which clearly indicate that
किस पेज पे है आपका सब्सटेंशियल
it
क्वेश्चन?
is page 11,
रोमन 11।
no, page 11, memo of appeal. Never transferred by Ramdev Master to Bhagwat Prasad, and his son Ramdev Kumar has no subsisting title and interest.
इतना लंबा सेंटेंस में आप सब्सटेंशियल क्वेश्चन ऑफ लॉ बनाए, छोटा करिए उसको। आधा पन्ना का सब्सटेंशियल क्वेश्चन ऑफ लॉ।
जिस्ट में वही है।
हमको तो समझ ही नहीं आता।
नहीं।
आंसर कैसे करेंगे इसको?
इसमें
हाफ अ पेज का सब्सटेंशियल क्वेश्चन।
इसमें जिस्ट यही हुआ।
आप उसको ब्रेक करिए ना।
अब ब्रेक कर।
करिए।
इसमें मेरा इसमें यही कहना है कि जो प्लॉट इन क्वेश्चन जो है 381 जो है, दैट वाज नेवर विद द Randhir Kumar Singh, as because his father had already sold it, and my lord, as because he was not having any valid right title, so my lord, he could not transfer the same to the defendant. This is one issue.
He executed a deed with respect to the property which was already sold.
A property,
Did he execute the deed with respect to the property which was already sold?
as per the finding of the learned trial court, he had sold my lord 3.98 and half. He was at best a share of 4 acres. So my lord may not, so far as his share, your lordship, is concerned, when he has sold out all my lord his share, so then my lord, there was no occasion my lord for the father my lord, to make a partition and my lord give it to the relatives. That's what I want to say.
He sold after partition, who knows?
Prior to that, 1974 itself, my lord, several share deeds are on board.
Do you want to say, I will record it, do you
What?
want to say that the father had already sold the entire share
His entire
prior to sale by the son?
Yes, that what is not said.
So the property which was covered by the sale deed executed by the father is the same as the property covered by the sale deed executed by the son. They are identical,
My lord,
almost identical.
let me clarify. So far as the plot in question, your lordship, is concerned, plot in question, your lordship, though it is mentioned in the share, but my lord,
Which share?
this by virtue of which the my lord, the Ramdev Mahato my lord, sold it to my lord Bhagwat Prasad Singh. But my lord, as because he has only 4 acres of land to his share, so my lord, after making a threadbare analysis by the trial court, has concluded that so far as the 380 your lordship plot, 381 which is the plot in question is concerned, my lord, that was never actually sold.
That was never sold.
That was actually never sold. It remained with my lord, the plaintiff's ancestors. That what is the finding of the trial.
If that is so, then you should be happy that it was never sold.
No, now they have sold it by virtue of my lord, this sold it, and he is interfering my position. That is the occasion, my lord, for the suit, my lord.
It was a specific case that this property was in joint name of 2 persons, right?
But
And then Ramdev Mehto had
Yes.
purchased 4 acres out of 8 acres.
He sold out 4 acres of his share, my lord. He, being a one of the son of one of the recorded son, my lord, he had 4 acres. Total area of my lord, khata number 21 is 8 acres. Out of which 8 acres, my lord, 4 acres is concerned, which always remained with us. So far as the 4 acres your lordship is concerned, he has sold it in the original deed, though the plot number 380 is there, but there was no specific boundary, only share was mentioned. And when the subsequent sale deeds, your lordship, in the sold out in the year 1974, so these are the documentary evidence. The learned trial court has concluded that yes, what he sold, he was well aware. And ultimately concluded, my lord, the plot in question was remained with us and it was never sold. So, my lord, there is no occasion for any partition giving it to, my lord, the vendor of the defendant. This what is the matter.
There is the finding of the trial court that the property which was allocated to you was never sold.
Yes. My lord, it is page 56. I had just read out. Page 56, नीचे से दूसरा पारा जो specific, my lord, it's a small paragraph I am reading. It is well certain that a partition may be informed of the cumulative circumstances and acts of the party. In the present case in hand, though the sale deed of Bhagwat Singh does not make clear as to which plots were purchased by him in the 21, but inscription of the three sale deeds in him in the year 1974 itself with the specific areas of each plots makes it abundantly clear as to which plot were actually purchased by the Bhagwat Prasad Singh, which was in possession of the Ramdev Yadav. The table shows that the land of Khatan plot number 381 remained with Megan Mato, who is the father of plaintiff number 1 and the grandfather of plaintiff number 2. The table makes it clear that the total area of plot was not sold to the Bhagwat Singh. Hence, the plaintiff are claiming 56.5 acres. छोटा सा हुजूर ये पेज 8 में दिखा जाए, इसी को बनाया जाए। मेमो ऑफ अपील का पेज 8 है। For that, the learned appellate court, while reversing the judgment and decree passed by the learned trial court, also failed to appreciate that the vendor of the defendant, Ramdev Kumar Singh, had no title interest to estate sale deed, and the suit land was never sold to Ramdev Mato by his father, Bhagwat Prasad Singh. पार्टीशन डॉक्यूमेंट भी नहीं प्रोड्यूस किए पा रहा है, एक भी नहीं है।
Or the learned counsel with the appellant. It has been submitted that the learned trial court, while decreeing the suit, had recorded a findings that the land at plot number 381 remained with Megan Mehto, who was the father of plaintiff number 1 and grandfather of plaintiff number 2 and 3.
Plaintiff was father of plaintiff.
and grandfather of plaintiff number 2 and 3.
2 and 3.
He submits that a charge was prepared with respect to the various
Said
areas, say deeds, and the learned trial court came to a definite finding that the table made it clear that the total area of plot number 381 was not sold to Bhagwat Prasad Singh. Hence and that the plaintiff was claiming 56.5 decimal of plot number 381, leaving half decimal on the basis of calculation. The learned court also held that the total area of khata number 21 sold by Bhagwat Prasad Singh came to 3.9.5 acres actually and not 3.99 acres as claimed by the plaintiffs. And the table showed that the total remaining land of Meghan Mehto was 4.01.5 acres. That is 1.5 acres more than his share. The learned counsel submits that the finding of the learned trial court was reversed by the learned first appellate court. And he submits that the following substantial question of law arise for consideration by this court. Roman 7 की Roman 8.
Roman 7 भी है जो 8 उनके पॉइंट ऑफ व्यू से है कि कोई पार्टीशन डॉक्यूमेंट तो नहीं क्लेम के लिए तो
7 and 8 दोनों पढ़िए. ये ना इसी को क्वेश्चन बना के ये ग्राउंड्स में है फॉर दैट करके है पेज नंबर 8 में. ठीक है, मार्क करते हैं इसको. This appeal is admitted for final hearing on the future substantial questions. ऐसे फोल्ड किए हैं, ध्यान रखिएगा कौन सा. Issue notice to the respondents. For which requisites under.
No, I have already appeared.
You have already appeared. All the respondents.
All the respondents.
The
Because in the limitation matter
the
notice
learned
is not
counsel for the respondents is present. He accepts notice on behalf of all the respondents. He submits that he has already entered appearance by finding vacant. Call for the records. Post this case under the heading for hearing on 17th of November.
Item 28, second appeal 446 of 2018.
Yes. So the appellant. What was the suit for?
Suit was for the declaration of the title over the suit land. Now he has lost in both the first trial court as well as the appeal court.
What was his basis for claim?
The basis for the claim was
Parwana, 1945 and delivery of possession followed by Jamindari rent receipt.
one LD case was number 2 of 51 and 51.
Plaintiff did not depose before the court. Nobody appears on behalf of the appellant. No adjournment notice has been circulated. The plaintiff is the appellant before this court against concurrent findings as pointed out by the learned counsel for the respondent.
I'm appealing question number 1 to 3.
Who is appearing on behalf of respondent number 1 to 3. The case was adjourned on various occasions. Upon payment of cost of rupees 1,000, 2,000, 4,000 and 8,000 on 4 different occasions. Since nobody is appealing on behalf of the appellant, this appeal is dismissed.
From supplementary list under heading for orders, item 1, first appeal 22 of 2008.
Notices upon respondent number 1H was issued through the police station. That has been, the service report has come, it has been validly served through person.
18.
180.
It has been served. FA number 22 of 2008. Learned counsel for the appellant has submitted that, as per the office note, the notice upon respondent number 1/8 has been duly served to the concerned police station. Personally, submits that the notice be accepted as valid, considering the submissions. Notice upon respondent number 1/8 is also accepted as valid, sir. बाकी पे सर्व हो चुका है. He submits that as per the records, the notice upon all other respondents have been served. Who is respondent number 1?
Original
It's the
was-
same matter.
It's the same matter. It's one of the land reference. It's the last land reference case of the same batch. FA 30 of 2008 was.
That's The learned counsel submits that this case is squarely covered by the judgment passed by this court in first appeal number 10 of 2008 on 12th of June 2019, whereby the cases were reverted back to the learned court for consultation. Remit हुआ था ना? Correct?
Yes.
Somebody has appeared on behalf of the respondent. किसी का appearance है?
On the previous date, Hariprakhar Sinha had appeared for the interviewees.
Pose this case for final disposal day after tomorrow to be taken up as first case at 10:30.
Item 2, first appeal 157 of 2018.
IA has been filed for continuation of delay. There is a delay of 28 days and almost cases are not bad cases. The delay has been controlled.
Any objection? Thank you. FA number 157 of 2018, the learned counsel for the parties are present. It has been submitted that IA number 2484 of 2022 has been filed seeking condonation of delay of about 29 days. The learned counsel has referred to the amendments made in the interlocutory applications. The learned counsel for the respondents has no serious objections so far as prayer for condonation of delay is concerned. Raised the interlocutory application and after hearing the parties, the IA number 2484 of 2022 seeking condonation of delay is here. और कोई डिफेक्ट है?
Yeah.
अब ये कौन सा
ये federal
कवर्ड
covered
जजमेंट बताइए.
judgment.
The learned counsel for the आपको भी कुछ बोलना है covered. The learned counsel for the appellant has submitted that
178 of
the present case is covered by the judgment passed by this court in FA number 164.
main case was that was 176 of 2018. Mostly this was decided.
In FA number 176 of 2018, and then the same judgment was followed in FA number 164 of 2018. It submits that the impugned judgment in the cases are the same. Same impugned
Same,
judgment.
it has been not of the same order and judgment.
ये कौन सा LR केस कौन सा है ये?
ये LRT starting from 73 to 100 of 2012.
73 to 100.
100 to 2012 and 240 and 241.
इस केस में
ये LRT से.
LR केस नंबर इसमें तो 92 है.
Starting from 73 to up to 100. The 92 comes in.
The learned counsel for the respondents has submitted that this case be also disposed of in the same terms.
Yes. Admit.
हाँ?
Admit case.
Admit हुआ हुआ है. ये तो नहीं admit.
Admit नहीं.
Formally admit करना है.
That is similar for the fixing.
Formally admit करना है. इसका records हम लोग के पास है. बना दीजिए. हाँ. क्या करें? एग्री कर दें? कवर्ड है क्या करते?
There is nothing already covered. Everything.
Same terms is disposed of. He has also submitted that no formal admission is required in this case, as the case is fully covered.
Okay, has already been appreciated.
Next is also same, identical.
Delay भी उतना ही है.
Delay जो है, सब कुछ everything.
Item 3.
Delay भी same है. This is IE number 2489/22. Same order कर दीजिए. इसका delay का note कर दीजिए. This is 29 days. Same order.
Item 4, second appeal 193 of 2018.
The order date is 27th of August 2025.
Yes, what do you want to say?
In pursuance of this order, the notices were delivered to the respondent in the executing court, but the advocate for the respondent, leading for the respondent in the executing court has denied the service. The
Here is the affidavit that he has denied the
affidavit is
service.
filed on 17/9/2025. Inadvertently, the affidavit was not being, the appellant was not able to file the affidavit within 2 weeks of the order. The order states.
Where is the affidavit? I don't see it.
Your Lordship, it has been filed on 17/9/2025.
You say it has been served.
No, Your Lordship. It has, because the respondent advocates denied the service, he denied from taking the notice of service. Further, this execution case was listed on below the in the
This is not the way to serve notice.
Your Lordship,
It has to be served in presence of witnesses.
Your Lordship, I'll further make a oral submission. The execution case was then listed on 19th of September. The same notices were put before the learned executing court. Then also the respondent's advocate denied the service of the notice.
What kind of oral submission is this? This is the way you would serve notices? Notice has to be served, even denial has to be served, done in favor or in presence of witnesses. Some advocate will certify that he refused. Some advocate can certify that he refused without any witness. Not proper. You can't do anything. You take Dasti. We do not. You take Dasti. Where are they residing? What is the address?
Jamshedpur.
जमशेदपुर का यही कहानी है.
Your Lordship,
This is second appeal of the year 2018. Substantial question of law has been framed.
yes. Your Lordship, the substituted legal heirs of the respondent, original respondent.
By
have-
which order substantial question of law has been framed? Which is that order?
Your Lordship, order dated 6/11/2019, order number 3.
And who are the respondents who are avoiding notice?
Your Lordship, they are the substituted legal heirs of the original respondent number, the sole respondent. And the notices have been validly served on respondent number 1, A, B, and D.
Only C is avoiding.
Yes, yes, Your Lordship.
Essay number 193 of 2018. The learned counsel for the applicant is present. He submits that notice has been validly served upon respondent number 1A, 1B, and 1D
Yes.
as per the records.
Yes.
And so far as respondent number 1B is
1C.
1C is concerned, the appellant has taken steps how do you see it is validly served? कहाँ लिखे हैं it is validly served? You were supposed to take fresh service upon respondent number 1A to 1D as per the last order.
That has been done, and
He submits that pursuant to order dated 27th of August 2025, fresh steps for service of notice upon respondent number 1A to 1D through the advocate representing the aforesaid respondents before the executive court was taken. And he has also referred to the affidavit dated
17/9.
supplementary affidavit dated 17/9/2025. Annexing therewith a certificate issued by the advocate stating that by the concerned advocate of the appellant stating that the advocate who was representing the respondents in the executing court has refused to accept the notice. However, the said certificate is not accompanied by however, the said certificate cannot be accepted as due compliance of this order, as there is no witness with regard to refusal. कभी पुलिस स्टेशन से गया उनके पास?
No evidence.
Let notice be issued to the respond number 1A to 1D through the concerned police station, for which requisites be filed by the appellant within a period of by Friday. The notice be served in presence of witnesses. Post this case on tenth of November. The further proceedings in the interim order dated 27 August 2025 shall continue till 10th of November.
Your Ladyship, the next date for execution case is 16th of.
16th
It will cover election. It will cover.
Let this order be communicated.
Obliging.
From the daily list under heading for orders item 8, second appeal 25 of 2017.
Who's for the respondents? How alias name can come? Alias name of respondent number 16, 17, 21 and 22.
This 16 is Siddharth Ganju alias Rajesh. 17 is
How alias name Wakalatnama will be accepted? Is there any alias name in the record?
Your Lordship will kindly see 16. For example, respondent number 16 is Madai Ganju alias Rajesh.
Ramesh.
Sorry. Ramesh,
As well, there is a correction. 12, there is no alias name.
yes,
I have to tally the wakalatnama
I'll do that.
with the records.
I'll do that.
AC number 75 of 2017. Also for the parties are present.
Normally in civil matters, I think there should not be alias name.
There
Whatever
cannot be
name is
alias
coming from the original suit,
Yes. There is no alias name, Mr. Mehta. You never
at
know.
best the defendant may
Mr.
say,
A says I am alias to Mr. B, and at the executing court, Mr. B will take the property of Mr. A. Possible?
So if it is an alias name,
Yes.
It
It is
is
quite
so.
possible.
it is quite possible.
In
So-
criminal matters, we don't bother because they are not the persons who are actually giving their names. So
Now
multiple
if there is
names
a
are
wrong name mentioned,
there. Spelling
supposingly-
also makes a difference.
supposingly I am defendant number 2 Anup Mehta. If my name is not correctly written, I can say in the written statement
Yes, certainly,
that this is not my name.
certainly. And suppose a check
Alright.
is to be issued, can you issue check with a different spelling?
No, certainly not.
Then
One small mistake, they'll throw it off.
one small mistake they will throw it off. Not possible. You do the necessary correction. Essay number 75 of 2017. I think you'll have to file fresh wakalatnama.
Hmm.
I'll tell you why. The deponent has given a wakalatnama with the alias name. If you delete it, it has a beard.
I'll just check up.
Yes. The learned counsel for the respondent submits that as per the office note, respond number 16, 17, 21 and 22 have executed wakalatnama by alias name. He needs to, he prays for time, he permits, he prays for time to verify and if required file a fresh wakalatnama. उस पे cutting मत करिएगा.
नहीं करें. Court master.
Post on 13th October.
Item 9, second appeal 44 of 2019.
In this case, after admission, notice were issued to the proposed substituted defendant. Because the original respondent, she died issued, and the property was sold to this proposed respondent.
So what happened? It is
So,
in orders. What do you want? You are the appellant.
I'm the appellant.
क्या करना है?
तो उसमें सर्विस रिपोर्ट आया है कि he has received the
Personally, sir.
personal by
To the
the
representative of respondent number 1. Who is respondent number 1?
respondent number 1, original respondent number 1 died, my lord. Thereafter, my lord, his wife was substituted. She also died issue days. Mustari Begum was the wife. And thereafter, but prior to that one, the husband has sold the property in favor of one, my lord, his name is Habibur Rahman.
Mustari Begum has died.
Yes.
You must have filed an application for deleting her
Yes.
name.
Yes. I have filed the application.
That which is IA number.
IA number is 10568/2020. No, sorry, 6357 of 2025. Yep.
6357. This is under order 22 4A.
4A. Because
You are the
there is no legal heir, madam. And the
No, it is for substitution of the sole appellant.
First prayer is for deletion of the name of the respondent, madam.
This is what you have done.
The application is My lord, for deletion of name of respondent number 1 who died issueless and for 6357 of 25.
Yes.
This application was order to do an application to so and so for substitution of sole app. Sorry, it appears not. In the body, my lord, it is correct. My lord, in the part.
So according to you, respondent number 1 is to be deleted.
Deleted and in her place, proposed respondent, my lord, who is.
Why? From where do you get proposed?
The property was sold to one Muhammad Rahman. I have annexed the sale.
He cannot be substituted.
My lord, under Order 22, Rule 4A, my lord, a person who is interested in the state of the.
Not as a substitution, but as an addition.
As an addition. So I
As
have
an
made
addition.
that.
Whom are you proposing to add?
My lord, name of.
Para 11. Okay. IA number 6357 of 2025 has been filed. इसका notice complete है ना?
हाँ, notice उसमें report तो बता रहा है कि he has received.
Served to the representative of respondent number 1. You can't say representative.
Because he is not the respondent, he is proposed respondent number.
ये personally served upon the इन्हीं को notice किए थे हमने.
हाँ, उसमें report में.
Respondent number 11 को notice किए
हाँ,
थे.
ये पारा 11 में जो नाम है हाजी.
फिर किसको notice किए थे?
आदि जफर नफीस खान. He is the पारा 11 में उनका नाम.
Delete तो already हो चुके हैं.
हाँ.
Also for the appellant is present. IA number 6357 has been filed for substitution of the sole appellant, namely Abdul Khalid Khan, who died on 24/4/2021, and also for deleting the name of respondent number 1, who is said to have expired on 3/6/2024. A prayer has also been made to add the purchaser of the property, whose details have been mentioned in paragraph 11, so that the estate be represented, inasmuch as the learned counsel has submitted that prior to death of respondent number 1, the property was already sold to the proposed person
Is at
detailed
present.
in para number 11. कब transfer हुआ?
My lord, there are two transfer, my lord. First transfer is.
By registered SEDI dated 8.
First transfer is 8/12/2008.
28/6/2003 and 8/12/2008. 2003 लिखे हैं आप इसमें.
First sale is
28/6/2003 वही है आप. SEDI में भी वही. और इनका who is to be substituted for the sole appellant? उनका वकालतनामा का.
But sole appellant has already been substituted, madam.
He has already been substituted. The learned counsel has submitted that the sole appellant has already been substituted by earlier audit. After hearing the counsel for the appellant, let the name of respondent number 1 be deleted from the cause title, as she is said to have died issueless. However, further, the name of the person whose details have been mentioned in paragraph 11 is directed to be added as a party in this case. Who
Party
is
respondent.
party respondent in this case, who is said to be the purchaser of the property prior to the death of, much prior to the death of
Original.
respondent number 1. Are you allowed? The counsel for the applicant is directed to do the necessary insertion. इसमें लिखिएगा added,
Yes.
substituted नहीं है.
हाँ, added.
During the course of the day in reading. अब इनको फिर से नोटिस करना होगा. इनको नोटिस हुआ तो आए क्यों नहीं है? Why didn't you come? Not interested in the property.
Actually, he is in the possession of property.
Let notice be issued to the newly added respondent through the concerned police station, for which requisites be filed by Friday.
Notice of appeal. Because earlier we
बाकी
have.
तो हो गया.
हाँ, party appeal.
और कोई बच्चा है जिसको नोटिस करना है?
नहीं, बस एक ही नहीं.
बाकी को नोटिस हुआ?
हाँ, सब बाकी है ही नहीं कोई. बाकी का डेथ भी हो गया और they are former party and there is no such. So only this person is as there is no other respondent.
No other respondent. तो फॉर्मा है?
उनका भी डेथ हो गया है. There was no legal.
And 3-4.
हाँ, वो सबका सब्स्टिट्यूशन जो है पहले से जो है डिलीशन का.
3-4 शेख अनवर अली, शेख अकबर अली.
हाँ, वो सबका पहले हो चुका है.
नोटिस हो चुका है, सर्व है.
वो डिलीशन का हो गया हम लोग का नाम.
डिलीशन.
ये हाँ सब्स्टिट्यूशन के बाद जो है पहले जो.
आप समझ ही नहीं रहे हम क्या?
हम समझ रहे हैं रिस्पोंडेंट नंबर 2 का जो है लीगल.
डिलीट हो गया.
हाँ.
इनको कभी नोटिस हुआ है कि नहीं?
हाँ,
रिस्पोंडेंट नंबर 3 या 4 को.
हाँ, हुआ.
तो कहाँ है सर्विस रिपोर्ट?
एक बार जैसा.
आप टेनेंट है ना?
नहीं, हम लैंडलॉर्ड.
लैंडलॉर्ड. नहीं,
हम इसमें
कभी नोटिस नहीं हुआ. Respond number 3 and 4. And also to respond number 3 and 4. 3-4 पर फिर से नोटिस जाएगा आपका तो इंटररोगेटरी स्टेज में नोटिस किया.
after admission.
On the main application. Post on 10th November. आपका कुछ है?
Serial 2 जो substitution has been typed.
कहाँ है?
Delhi.
अपीलेंट का सब्स्टिट्यूशन है कि
एक में appellant type की है, second में respondent. Serial 2 और 5.
2 और 5 एक साथ हैं. अलग-अलग
है लेकिन party portion एक में appellant type की है, दूसरे में respondent.
है क्या उसका? फाइल तो चला गया होगा ना? फाइल चला गया ना? कल के सुबह आ जाइए. सुबह ही आ जाइए.